Imagine this scenario. You spent months saving money. You organized all your belongings. Your visa application was successful. You took a 14-hour international flight. You arrived at JFK, LAX, or Chicago O'Hare. You approached that CBP inspector with confidence. Then they called you aside, not due to current misconduct, not due to criminal activity, but due to information you weren't aware existed in your records, patiently waiting to prevent your admission. The challenging part is you held a valid visa. Here's the information rarely shared before departure. A visa does not provide guaranteed entry into the United States. Not at all. And in 2026, with regulations becoming stricter, the importance has never been greater. I'm Mark, and this is America Door, the channel where we present immigration law clearly. We explain it so it protects your situation, your immigration standing, and your family's well-being. Today I am going to explain the specific legal challenges that are affecting travelers at U.S. airports currently. Travelers with valid visas, approved estes, even permanent resident cards. And then I'm going to provide you the legal protection, the specific approach to safeguard yourself before you board that aircraft. Watch until the conclusion. This video could be the most valuable content you review before your upcoming trip to America. Now, before anyone comments says, "Mark, you're overstating this." Let me demonstrate exactly where this originates. This is not personal perspective. This is federal regulation. Under the Immigration and Nationality Act, the INA, and specifically under 8 CFR Part 235, every single traveler who arrives at a U.S. airport is legally classified as an applicant for admission. Let me repeat that carefully. Every single traveler. It doesn't matter if you have a B1, B2 visa. It doesn't matter if you have an F1 student visa. It doesn't matter if you have an approved ESTA. The moment you arrive, you are legally requesting permission to enter. And it is a CBP inspector at that checkpoint, not the State Department that issued your visa, not USCIS, who makes the final determination on whether you proceed through that entrance or get placed on a flight returning home. The State Department provides you the visa. CBP determines admission. These are two completely separate decisions made by two completely separate agencies. And CBP, they report to the Department of Homeland Security. Their jurisdiction at that airport is nearly unlimited. This is the situation. Now, let's discuss where travelers are experiencing difficulties because they didn't understand this. This is the #1 challenge, and it is affecting travelers significantly right now. You have a valid visa. It hasn't reached expiration. You obtained it from the U.S. Embassy. You followed all procedures correctly. So, you believe you're guaranteed to enter? Incorrect. Here is the harsh legal situation. A U.S. visa or an approved ESTA is only a travel authorization. It gives you permission to travel to the United States and request admission. That is all. The CBP inspector at that port of entry can review your record, your travel history, your prior entries, your past conduct, reports filed against you, and determine right then and there that you are inadmissible. They can invalidate your visa immediately. They can place you back on a plane. And depending on how they refuse you, you could be prohibited from returning for 3 years, 10 years, or permanently. So the next time someone mentions your visa is acceptable, don't worry. You inform them Mark said that is not sufficient. This challenge has quietly affected thousands of immigration cases, and almost nobody discusses it. When you enter the U.S. as a non-immigrant, a tourist, a student, a worker, you receive something called a Form I-94. It is your arrival departure record. It is issued by CBP at the airport, and it indicates exactly how long you are legally permitted to stay. That date, the I-94 date, is your actual deadline, not the visa expiration date. Your visa might indicate it expires in 2028, but if your I-94 indicates you must leave by June 15th and you stay until June 20th, you just overstayed unlawfully, even while your visa was technically still valid. And here's where it becomes serious. Every single day beyond that I-94 date is counted as unlawful presence. Stay 180 days beyond it, and you receive a 3-year prohibition from re-entering the U.S. Stay 1 year beyond it. A 10-year prohibition, the government monitors. CBP observes it the moment you approach that checkpoint on your next trip, and that inspector is going to request you to explain it. Verify your I-94 right now. Go to i94.cbp.dhs.gov and verify your record. Don't assume. No. If a CBP inspector ever says to you, "Please accompany me to secondary inspection," I need you to take a deep breath and stay composed. Here is the misconception most travelers believe. Secondary inspection means I'm being refused. That is not accurate. Secondary inspection is a standard procedure CBP uses when it cannot quickly verify your records, when your documents are incomplete, or when there are alerts in the system that need to be resolved. It is not a conviction. It is not a guaranteed refusal. But here is where travelers turn a manageable situation into a problem. They panic. They get nervous. They change their story. They provide inconsistent answers between primary and secondary. They try to be too clever, volunteering extra information that raises more concerns. When you are in secondary inspection, you answer the questions. You answer them honestly. You answer them consistently. And you do not volunteer information that was not requested. If you are traveling for tourism, say tourism. If you are visiting family, say visiting family. Have your documents, your hotel booking, your return ticket, your bank statement organized and ready. Your credibility in that room can be the difference between departing the airport with your family or boarding a flight returning home tonight. Now we are entering territory that surprises most travelers, and I want you to understand this clearly. CBP believes it has the legal authority to examine your phone and your laptop at the border without a warrant, without suspicion, without even providing you a specific reason. This is called the border search exception. The government's position is that at a port of entry, an airport, a land border, a seaport, normal Fourth Amendment protections work differently. They say national security at the border justifies broader examination authority. Here is what the ACLU has to say about this, and this is important. You can, and the ACLU says you should clearly and calmly state, I do not consent to an examination of my device. But, and I cannot emphasize this enough, if you are a non-citizen, a visa holder, or even a permanent resident card holder, refusing to cooperate can result in further detention, your device being confiscated, and potentially a refusal of entry. Citizens cannot be refused entry for declining. Non-citizens can. So, what do you do before you travel? Prepare your devices. Remove applications with sensitive content. Back up and log out of messaging applications. Use a travel phone if possible. Do not carry what you cannot explain. This is not excessive caution. This is 2026 travel approach. I observe this every week. A lawful permanent resident. Someone with a permanent resident card returns from a trip abroad. They think they are secure. They have permanent residency, and CBP places them into secondary and questions their entire status. Here is the regulation. If you are a permanent resident card holder and CBP believes you have abandoned your U.S. residence, that you have been living abroad, that the U.S. is no longer your true home, they can question your admissibility right there at the airport. They can place you in secondary. They can send you to an immigration judge. An immigration judge can remove your permanent resident card, and that is a challenge that takes years and thousands of dollars to address. If you have a permanent resident card and you have been outside the U.S. for extended periods, you need a reentry permit before you travel, not after. Before, and you need to maintain your connections to America, tax returns, an address, financial accounts that prove this country is your home. All right, enough of the challenging news. Let me now provide you the approach, the actual professional level guidance that will protect you every single time you arrive at a U.S. airport. Regardless of your immigration status, the moment you are inside U.S. territory, even at the airport, you have constitutional protections. The Fourth Amendment protects you from unreasonable searches and seizures. You have the right to remain silent on questions beyond basic biographical information and your purpose of visit. You have the right to ask, am I being detained and why? And if you are formally placed in removal proceedings or detained beyond the initial inspection, you have the right to contact an attorney. Request one clearly on the record. Every time you travel to the U.S., carry these documents organized, printed, and ready. A return or onward flight ticket. A hotel booking or letter of invitation from your host. Bank statements from the last 3 months showing you can support yourself. An employment letter or proof of business connections back home. For students, your I-20DS 2019 or other required academic forms for permanent resident card holders traveling abroad. A reentry permit if you have been gone more than a year, and any prior I-94 records showing a proper departure history. This is your admissibility protection. The inspector at that checkpoint is asking himself one central question. Is this traveler who they claim they are? And will they depart when they're supposed to? Your documents answer that question before they even ask it. Rule number 1, do not provide false information ever. Rule number 2, answer the question asked, nothing more. Rule number 3, be consistent. What you stated at the primary checkpoint, say the same thing in secondary. Rule number 4, if they ask to examine your device, you may calmly state, I do not consent to this examination. But if you are a non-citizen, understand the consequence and make an informed decision. Rule number 5, if at any point you are told you are being formally detained or placed in proceedings, immediately ask to speak with an attorney. Do not sign any documents until you have legal counsel. Sometimes CBP cannot resolve the admissibility question right there at the airport. So, they parole you into the country and give you a written notice to appear at a deferred inspection site within a specific time frame. This is not a favor. This is not them being lenient. This is a conditional entry. And if you miss that appointment or if you appear unprepared, your case can be escalated directly into formal removal proceedings before an immigration judge. Appear on time. Bring every document they requested. Bring copies of everything, and seriously bring an immigration attorney with you if you can afford one. This is the moment where legal representation proves valuable. Before your next flight to the United States, verify your I-94 record online. Confirm your departure was properly recorded. If there are discrepancies and overstays showing in the system that you know was an error, a departure that was never recorded, you need to address that with CBP before you arrive, not during your inspection. Contact a qualified immigration attorney. Get a legal opinion on your admissibility before you board because discovering a problem at the primary checkpoint at 2 a.m. after a 14-hour flight with no lawyer and no documents is not the time. I want you to understand something. The cases I've described today, the visa holders refused entry, the permanent resident card holders questioned at the border, the students turned away because of missing documents. These are real travelers. Travelers who did not know what you now know. Travelers who trusted that having the correct visa meant having guaranteed entry. You now know better. And knowledge in immigration law is everything. Because these regulations, they don't wait for you to catch up. They change rapidly. A new directive, a new enforcement priority, a new policy memo from DHS, and the calculation at that airport checkpoint shifts overnight. That is exactly why I need you to join our free official WhatsApp channel. The link is in the description below. This is where we send urgent 2026 immigration updates. The moment a new CBP directive appears, the moment courts issue a ruling that affects your rights at the border, the moment something changes that you need to know about before you fly, it is free, it is official, and it could be the difference between arriving safely and being sent home. Now, here's what I need from you right now. First, press that like button. This took serious research to put together, and it helps this video reach the travelers who need it most. Second, and this is important, share this video to your family WhatsApp group. Right now, you probably have family members, friends, or people you care about who are planning to travel to the US soon. They need to watch this before they board that plane. One share could save someone's visa, their status, their future. And third, hit subscribe and activate that notification so you never miss a video. Because on this channel, we don't report the news. We translate the law into your protection approach. I'm Mark. This is America Door. You now know what they didn't tell you at the embassy, what the travel agent didn't warn you about, and what could have surprised you at that airport checkpoint. Now go prepare, travel smart, and protect your future.